Hello guys, welcome to another video. So in this session, we will be discussing the center-state relations, very important topic for your polity. So if you see in any country, there are different forms of governance, right? Two of which are particularly notable. That is the unitary form of government, right? So there is a unitary form of government, and here central government holds a maximum or even sole power. So this means that all decisions comes directly from the central authority with minimal or no interference or no role for regional entities or states. A classic example of unitary system include countries like UK and France. Okay. Now, the other side, in contrast to this, if you see the federal form of government, which divides powers between the center, that means the central government or the federal government and the individual states or provinces. It varies depending on the country. So that ensures each level has its areas of jurisdiction. And United States, Canada, Australia are classic examples for the federal system. In India, our governance structure is actually unique. And if you see during emergencies, India temporarily function like a unitary state with most of the powers will be concentrated at the center. But under normal circumstances, India follow a federal structure. So here, in that case, the powers are balanced between the center and the states. And this unique blend basically allow the government to adapt as per the nation's requirement. So this is what we are going to discuss in detail in today's session. So let me share the PPT, and with the help of that, we will proceed further. So what is India's federal structure? Why it is unique? Okay, and all those things we will be getting into the details of it. So we basically discussed about what is federal and what is unitary. We have discussed the example also. Now let's look at division of power in India. Okay. So let's try to understand India's federal structure. Okay. See, in a federal setup, if you see, the main feature is division of power between the center and the state. So when it comes to India, the division of power is categorized under three broad categories or broad relations, which are outlined very clearly in the constitution, and it is deriving from the constitution. First is legislative relations, and which cover the lawmaking process. And then comes the administrative relations, which focuses on administrative authority and control. And then comes the financial relation. So that will handle the financial responsibilities and the revenue distribution. See guys, the legislative relation between the center and the state are primarily found in Article 245 to 255. So these articles clarify who can make laws for which regions and on what subjects, which create a framework to prevent conflicts. Correct? Now, let's move on to legislative relations and its key aspects. So, guys, the legislative relation between the center and the state can be divided into two aspects, that is territorial jurisdiction and subject matter jurisdiction. So when we talk about the territorial jurisdiction, that defines a specific geographical area where the law applies. Now coming to subject matter jurisdiction, this specify the types of subjects or the areas for which each level of government has legislative power. Let's examine both of these aspects, starting with territorial jurisdiction, which is covered under Article 245. So let's see if I have a slide for that. Yes, 245. See, Article 245 basically lays down the fundamental structure of legislative power in terms of geographical reach. So the clause 1 states that Parliament can make laws for entire territory of India or any part of it. And clause 2 grants state legislature the power to make laws applicable within their respective states. So I repeat, clause 1 that state that Parliament can make laws for entire territory of India or any part of it. Okay, and clause 2, that is for the state legislature, the power to make laws applicable within their respective states. So if you see, this article gives Parliament the authority to legislate for the entire country or specific region. Similarly, state legislature are empowered to make laws applicable only within their territory. So that's about this case. And now coming to extraterritorial jurisdiction of Parliament. Yeah, extraterritorial jurisdiction of Parliament. So that's actually again a unique feature under Article 245, that is the extraterritorial jurisdiction of Parliament. This means that Parliament can create laws that apply not only within India, but also to Indian citizens and properties located outside India. I repeat, not only within India, it can connect it to Indian citizens who are even outside and connected to their property also. So Indian citizens and properties located outside India. Okay, so for instance, if there is a law affecting Indian owned property abroad, Parliament has the authority to enact such legislation. However, please note this, state legislature do not have this extraterritorial power. State legislature have to make laws within the territory, but Parliament have extraterritorial jurisdiction also. Okay, so the validity of extraterritorial laws is basically determined using the territorial nexus test. Territorial nexus test as established in the Wallace versus Income Tax Commissioner case. And in this case, an English company earned significant revenue from India, which allowed Indian authorities to tax it based on its Indian income. So the territorial nexus test require a reasonable connection between the law and the foreign element that it affects. Okay, now let's also discuss about the exceptions under Article 245. See, although Parliament have the extensive legislative power, it's not absolute. See, when we talk about fundamental right, also we use the same language. It's not absolute right, subject to certain exceptions and reasonable restrictions and everything. So there are three major exceptions here. Now, first is with respect to union territories. For certain union territories, this comes under Article 240. Yeah, it's not there in the slide. Yeah, union territories under Article 240. For certain union territories, the president can make regulations that override parliamentary laws if required for peace, progress, and good governance. Okay, so president can make regulations that override the parliamentary laws if required for the purpose of peace, progress, and the good governance. Now, second one, coming to scheduled areas. That means the fifth schedule. Okay, so governors in states with with the scheduled areas have the authority to exempt these regions from certain parliamentary laws. So that's about this one. So that scheduled areas, this is coming under fifth schedule. So governors in states with scheduled areas have the authority to exempt these regions, scheduled areas, from certain parliamentary laws. Now coming to sixth scheduled area, see, in states with significant tribal population, for example, Assam, Meghalaya, the governor can modify or prevent parliamentary laws from applying to these areas. So that comes under sixth schedule. So significant tribal population is there. So here the governor can modify the laws with significant tribal population, modify or can prevent also the application of parliamentary law in the state. Governor have that power. Now coming to the territorial jurisdiction is over. Now let's look at the subject matter jurisdiction. This is coming in the seventh schedule. Okay, so let's move on to the subject matter jurisdiction, and that's the seventh schedule of the Constitution, which divide legislative subjects into three lists. Very important, guys. Seventh schedule, three legislative lists. That is union list, that is a list 1, state list, that is a list 2, and the concurrent list, that is a list 3. So union list contains 100 items of national importance like defense, atomic energy, etc. And here only Parliament can legislate on these items. Clear? So union list, only Parliament can legislate. Coming to the second one, that is a state list that contains 61 items of regional importance. First one, national importance. This is regional importance. So here, police, that means law and order is a state subject. Okay, public health, state subject. That's what I mean by state subject. So police, law and order like that, health, etc. Here, state legislature have exclusive powers to make laws on these items. So that is about state list. Okay, so that is regional importance. Now coming to concurrent list, it contains around 52 items on which both Parliament and the state legislature can legislate. For example, marriage, bankruptcy, etc. So in case if there is a conflict, now there is a state law and there is a central law. If there is a conflict, which one will prevail? Center. That means the Parliament will prevail in this case. So that's a three list. Now let's look at residuary powers. Again, very important. See, if a subject matter doesn't fall under any of the three lists. Okay, so Article 248 provides that the union retains the residuary power to legislate on it. So something is coming, it's not coming in any of the three, neither on the union list, nor on the state list, nor on the concurrent list. Then who will have the power? It is a union will retain the residuary powers to legislate. Under which article? Article 240. Very important. Now this ensures that central government can legislate on emerging issues, new issues which are coming, which is not mentioned in any of this, that may not have been anticipated when constitution was written. At that point of time, see, the society is evolving, new issues will come, new legislations need to be passed. So it may not be clearly defined. So whenever some new issues is coming, who have that residuary power? It is the center. Now let's look at this doctrine of pith and substance, okay, and repugnancy. So resolving conflicts, the key doctrines, okay. So see, sometimes a law may inadvertently overlap into another list. So to determine which law prevails, court uses the doctrine of pith and substance. Again, very important concept. See, this examines the primary purpose and essence of the legislation rather than the isolated sections. So if you look at this, if the core intent aligns with one list, the law is considered valid. Okay, so if the core intent aligns with one list, the law is considered valid. And the Bengal Moneylenders Act, that case is a classic example of this doctrine, where the act's main intent was regulating money lending, despite incidental overlap with other subjects. There were overlap with other subjects. So here, what is the prime intent? That's what the court will look at. So in that case, it will be valid. Okay. So additionally, again, Article 254 addresses conflicts between central and state laws on concurrent subjects. So if there is a conflict between center and state on the concurrent subjects, which article will address that? It is Article 254. If both pass laws on the same subject, okay, then the law made by Parliament will prevail. Under which article? Article 254. Now let's also look at some special circumstances. Guys, under normal circumstances, the division of subjects in the 7th schedule is respected. But in special circumstances, Parliament can legislate on state list also. So we discussed the Parliament can legislate on union list. Parliament and state can legislate on concurrent list. State can legislate on state list. But there are special circumstances that which we are going to discuss now. In that circumstances, Parliament can legislate on state list. Which are they? Like mainly national emergency. So during an emergency, Parliament can legislate on any state subject. Second, if Rajya Sabha passes a resolution, this question used to ask in prelims many times before also, now also is very important. That means if Rajya Sabha decides a state subject require national legislation and it can pass a resolution, that resolution will empower the Parliament to legislate on that subject. Okay, so national emergency, and then Rajya Sabha passes a resolution. Then if state request, so if two or more states agree that a subject on the state list need a national law, then Parliament may legislate accordingly. Okay, again, international agreement. So Parliament can legislate on state subjects to fulfill international treaties or agreements. So it's very easy to remember. If two or more states request, then Parliament will legislate. National emergency time. Now to follow something related to international treaties, and again if Rajya Sabha passes a resolution. So let's conclude, guys, now. Flexibility, yes, we discussed this. That flexibility comes during this exceptions. Okay, so what we can consider, in essence, I can say India's federal structure is designed to balance the power between the center and state, and it provides flexibility to adapt various circumstances. We discussed in case of Rajya Sabha passing resolution. We discussed in case of states requesting. We discussed also in case of international treaties. We also discussed in the case where national emergency situations. So there are a lot of flexibility which are involved in this. And the legislative relationship between the center and the state is not only foundational to India's governance structure, but also essential in preserving the unique diversity of the nation. So through a well-defined territorial and subject matter jurisdiction and a mechanism to resolve the conflict, and a judiciary which is taking care of all these to manage, and the constitution ensures ensures a dynamic but still a structured governance framework, and that is exactly what we need to discuss under this particular topic. So if you get a question, I hope whether it is prelims or mains, we have covered it in detail and you got a proper answer for mains also. So thank you so much. Thank you so much, guys, for attending the session. In case if you want any course or mentorship, you can get in touch with us. See you guys.